Israel acquired the West Bank and Gaza in the course of a war, namely the 1967 war. Therefore, Israel has no title to the West Bank and Gaza, and it explicitly denoted the West Bank and Gaza occupied Palestinian territory. The sovereignty issue has been resolved. Those are Palestinian territories. Number two, the International Court of Justice ruled that East Jerusalem was acquired in the course of a war, namely the June 67 war. It's inadmissible to acquire territory by war. Therefore, Israel has no title to East Jerusalem. It's occupied Palestinian territory. Number three, the International Court of Justice ruled that the settlements that Israel has built in the occupied territories are illegal under international law because under Article 49 of the Fourth Geneva Convention, it's illegal for an occupying power to transfer its population to occupied territory, and therefore the Israeli settlements are illegal. Now, there are several things to be said about the ICJ opinion. Number one, we're often told that the issue of the settlements, the Jerusalem question, the borders question, these are very controversial issues, that these are very intricate issues, and these are unresolved issues, so much so that they have to be deferred to what are called final status negotiations. But in fact, in the real world, they're not uncontroversial, they're not controversial at all. In fact, in the real world, they're probably the least controversial questions that have ever come before the International Court of Justice. Let me give you an example. The International Court is composed of very contentious, independent-minded justices. So for those of you who are a little bit older, you'll remember in 1996, the question was put before the ICJ, are nuclear weapons legal? Is the use of them legal under international law? The answer should have been a no-brainer, because a fundamental principle of international law is what's called the principle of distinction, the distinction between combatants and civilians. And it's illegal under international law to use a weapon that cannot distinguish between combatants and civilians. So you often hear, when Hamas fires one of its so-called rockets at Israel, they're immediately condemned for war crimes, not even if the rocket does not kill civilians, even if it doesn't, because the mere use of an indiscriminate weapon, regardless of its consequence, constitutes a war crime. Well, then what could be more indiscriminate a weapon than a nuclear bomb, which plainly can't discriminate between civilians and combatants, and will result in the deaths of numberless civilians? Well, the International Court couldn't agree on it. The vote was 8-7. The president of the court had to cast a deciding vote. They couldn't even agree on that. One judge from Sri Lanka, a very smart guy, an admirable fellow named Judge Veeramantri, he said, this is really weird. He said the international community agreed all the way back in 1899 that a dum-dum bullet was inhumane, because when you fire a dum-dum bullet in the body, it expands and causes excruciating pain. He says, we all agree that one dum-dum bullet is inhumane, but we can't agree that dropping a nuclear bomb, which can kill hundreds of thousands of people in the blink of an eye, is inhumane. Well, these judges couldn't. But here's the story. When it came to the issues, what we're told are the most controversial issues bearing on the Israel-Palestine conflict, on all three issues that I mentioned, borders, Jerusalem, settlements, there was no dissent. There was no disagreement. Every one of the judges agreed on those issues. There was another issue that came up, actually the main legal issue, namely the legality of the wall that Israel was building in the West Bank. And on that question, one judge dissented, the American judge, Thomas Bergenfeld. But even Bergenfeld, in his separate opinion, he wouldn't call it a dissent, he called it a separate opinion. He said, I have to agree with the majority on the question of the settlements. He said there can't be any question but that under international law, the settlements are illegal. And so on what's really the core issue on the Israel-Palestine conflict, or one of the two core issues, the settlements, even the dissenting judge agreed with the majority. There's no controversy whatsoever. Every time BBC or any of your newspapers, they refer to the controversial settlements, you have to ask them, controversial where? There's no controversy about the legality of the settlements. The final issue, which the court did not deal with because it wasn't relevant to the case that they weren't adjudicating the case, they were rendering their opinion on it, was the question of the right of return. The question of the right of return has been addressed, if not by the most respected legal body in the world, it has been addressed by the most respected human rights organizations in the world, namely Amnesty International and Human Rights Watch. And it will perhaps come as a surprise to you that both human rights organizations, in 2000 and 2001, they both upheld the right of the return of Palestinians and Palestinians who were expelled in successive generations who have maintained genuine links with the land. So what we can conclude from that admittedly cursory, but nonetheless, it seems to me, significant survey of the most representative and the most respected international institutions, we can conclude three things. Number one, the only obstacle to resolving the conflict, looking objectively at the record, is the U.S. and Israel. Number two, on all the legal issues bearing on the Israel-Palestine conflict, on all the legal issues, what I call the final status issues, borders, Jerusalem, settlements, and refugees, on all the legal issues, Israel's official position has been repudiated, and the current position of the Palestinians has been upheld. It's an across-the-board victory for the Palestinians on all the legal issues pertaining to the Israel-Palestine conflict. But there is a third fact that has to be borne in mind. And the third fact is all of the resolutions, advisory opinions, and human rights opinion papers, policy papers, they are all premised on the two-state settlement. They all start from there. The UN starts, we support a two-state settlement, and then it lays out its conditions. Full Israeli withdrawal from East Jerusalem, so on and so forth, and a just resolution of the refugee question. The International Court of Justice, it starts out by saying Israel is an occupying power in the West Bank, Gaza, and East Jerusalem. But it out from the premise that Israel itself is occupying territory. No. That's the point of departure.